Hello. Well, today we're just going to have a few of these recaps of the various topic areas we've covered. If you have specific areas you'd like something on, then feel free to email. So this is just an introduction overview of where we started the course and what we're trying to achieve with it. So you've got the access to the Canvas front page, which we're on at the moment. If you go down through that, everybody should be familiar with the contents of it. And here we have the partnership link. Just some of the main points that people are asking a few questions from off the front page, which is an introductory page. The first one is about the legal entity, and what you need to be very clear on there is that you cannot sue a partnership, it cannot own property, it can't enter contracts, and you can't prosecute it. You can, of course, prosecute the partners. They can be sued, they can own property, and the state can punish them. That's because a partnership is not a legal entity. It's often the case that we think of it as an entity because the IRD requires partnership returns and people do business under the structure of a partnership. But be very clear with who you are actually contracting with. Now, in terms of studying this, we have some key issues, discussion questions. You're aware of the worksheets, which will follow through the whole course, which you use in the assignment. What's quite important about partnership is to understand who the parties are. And the parties consist of the partners who are within the partnership structure and third parties. Third parties are simply everybody else. Where we go for the law on partnership is the Partnership Act 1908, and you can get that from Legislation Co. NZ. The Partnership Act is quite well structured. Be very clear, this is the Partnership Act, not the Limited Partnerships Act. A limited partnership is a different legal structure that allows for a form of limited liability on general partners. We are not discussing limited partnerships. We're only looking at the Partnership Act itself. So if we just scroll through the Partnership Act, you can see we have Part 1, the general nature law relating to partners. This is about formation of the partnership. So when you face a question in a test, is there a partnership, you will be using Section 4 and Section 5. Section 4 gives you the overview with 3 requirements: a business in common, a view to profit. Section 5 gives us some presumptions. So if the fact shows these things exist, there is or isn't a partnership. For example, in here, the receipt of a person of a share of the profits is prima facie evidence he or she is a partner. That means net profit. So if people share net profit, it's a partnership is the presumption, but you may prove it's not. Now, going back to the Act itself, Part 1 gives us that understanding of, do we have a partnership? And we don't need an agreement to form a partnership. The law just says if we have those requirements, we have a partnership. Now, when you break the rest of the Act down, you'll see the second part is relation of parties to persons dealing with them, relations of partners. So this is the partners as a group dealing with third parties or people outside of the firm being the partnership. There are a number of important sections in here, but the key ones we're looking at is the power of a partner to bind a firm. That's contract. So can one partner enter a contract on behalf of all other partners and make them liable? And we'll see, yes, they can, provided it's of the usual kind of business and the third party isn't aware that the person isn't allowed to do that. When you look at Section 8, it simply creates the power to bind the firm, in other words, to bind the other partners to a contract. It doesn't say what they have to pay, which is why whenever we use Section 8, we also talk about Section 12, which says every partner is liable jointly with the other partners for all debts and obligations while he or she is a partner. So while you're a partner, if the other partners enter contracts in the usual way of business under Section 8, you have to pay for it, which is why they have their hands in your wallet. You'll notice after a partner dies, the state is severally liable for their share. Notice with jointly means you're liable for everything. Severally comes from the word sever, or to cut, meaning you cut out the share that person is liable for. Other key sections in here we'll talk about later are section 17, person's liable by holding out, and especially 13, which is liability for tort. So if we don't have a contract with a person, they may sue us for torts such as negligence, defamation, nuisance, but primarily we're concerned with negligence. And whenever you use section 13, you use section 15 because that tells you what the liability of each partner is. And you'll notice it's jointly and it's also severally for everything while he or she is a partner. That means you can sue one partner alone for their proportion or all of it. That's because that person might be the one who drove through a red light and crashed into your car and you just want to sue them and not the other partners, but you do have the choice. This section is very important for liability. Now, if you go down through in our breakdown of the Act itself, so that part from 8 through to 21 was about relationships of partners to third parties, outsiders suing them in other words. Whereas the next group of sections is the relationships between themselves. So this is their internal rules. So they can create all the internal rules that the Act allows. And if they breach those rules, they can sue each other for breaching those rules. But they can't generally use those rules as a defense against the third party. For example, when a third party sues the partnership for breach of contract and the partners say, we didn't allow that partner to enter those big contracts, but they did anyway. That's an internal rule and it won't work against the third party unless they know about it. So what are we looking at within these relationships of partners one to the other? We're looking at a bunch of rules. So you go through those rules and you think about, well, how do they affect my business plan? And also, are they relevant in any test? So we have things like partnership property. Who owns the property? Is it contributed and therefore becomes partnership property, which means it's jointly owned by all the partners and in equal shares under section 27, unless they change that rule. Property bought with partnership money is, of course, partnership property. Section 27 is an important section because it creates a big pile of default rules. By default, we mean if you don't change them, they are your rules. So if you don't have a partnership agreement to change them, we didn't even realize it was a partnership, these will be your rules. And you can tell that you can change them because it says subject to any agreement. So we have quite a large set of rules here which are important to think through. Should we pay ourselves for working in the partnership business, or should we just, for example, get a share of the profit? It's just one example, but there's many in there you need to consider and decide, well, is this useful for my partnership? Would we have this in our business or would we change it? Now, if we go back, you'll notice also in this relationships of one to another, sections through to 34, we have expulsion. Can we kick someone out if they're lazy? What happens if one partner wants to leave? If they just give notice, the partnership's dissolved. Now, further down through here, we don't worry too much about financial reporting due to time issues. We have dissolution of partnership and its consequences. Very, very important in any business to consider what happens when it ends and can I end it and take my assets with me? In other words, exit. So we can dissolve it by expiration of notice. If our partnership doesn't have a term in it for how long it lasts, then it's considered to be at will under section 29 and any partnership can end it. Death, bankruptcy, someone dies or becomes a bankrupt, which is an order of the court, then the partnership can end. Illegality, dissolution by the court. If there's no other options and you can't get out of the partnership, you can go to court and ask the court to dissolve the partnership. But note, it says dissolution of the partnership. It is not about kicking a partner out. It is about dissolving the whole partnership, which means your partnership and your business ends and has to be restructured. That's not a good outcome most of the time. Okay, so we'll stop there. That's the major structure issues within the Partnership Act and the question of entities.